The draft constitution and the accompanying report were finalized and submitted on 30th March 2020 to His Excellency the President, pursuant to the requirement of Section 21(1) of the CRC Act of 2017. That section effectively ended the mandate of the Commission insofar as constitutional review was concerned. Thereafter, the only thing that continued to keep us in office to date was the obligation outlined in Section 22 of the CRC Act. That section essentially empowered the National Assembly to request CRC commissioners, quote, to attend before the National Assembly to clarify any matter and answer any question relating to the provisions of the Constitution, unquote. In the end, as you all would be aware, we were not requested to attend to clarify any matter or answer any question. Accordingly, in accordance with Section 22(1) of the CRC Act, the Constitutional Review Commission will stand dissolved on 22nd October 2020, which is 1 month after the date on which the bill introducing the draft constitution failed the required threshold for enactment. On that day, the CRC Secretariat and all staff and other persons employed by the Commission shall cease to function. However, the Secretary may stay in office with the approval of the Minister of Justice for the sole purpose of preparing the Commission's statement of accounts to submit to the Auditor General in accordance with Section 20 of the CRC Act. This is pursuant to Section 22(4) of the Act, actually. The Secretary may need to be assisted in this endeavor by a few staff in finance and human resources. As commissioners, we were given a specific mandate to review the 1997 Constitution and write a new one, and prepare a report in respect of the new Constitution. We discharged that mandate in a professional and non-partisan manner, bearing in mind particularly that the development of a new Constitution for any country has the sole purpose of determining and crafting in appropriate language what is in the best interest of the country in the present and in the future. Admittedly, that process is not as simple as it may appear. It is fraught with problems. In a perfect system, everybody's wish and aspiration would be taken care of. But we do not live in a perfect system and never will. The development of a national constitution, amongst many things, requires identification and placement of priorities. It requires sacrificing, in some cases, one's wishes and aspirations for the greater good, while at the same time gaining some. It requires learning lessons from the past in order to chart a bright and productive future. The ultimate goal is, to quote the Reverend Martin Luther King, to get to the promised land. And the hope is to get there together. At the CRC, we were quite pleased that both the Executive and the National Assembly charted a path for our work through the enactment of the CRC Act of 2017. That act outlines specific terms of reference for us as commissioners. The act specified that in carrying out our mandate, we must seek public opinion and embody in the draft constitution such proposals as we considered appropriate. We were fully aware that being vested with such broad discretionary power also meant exercising the power judiciously and without any abuse whatsoever. The rules of natural justice demand appropriate judicious exercise of discretion. Furthermore, the act required us to have regard to our national values and ethos as a country. In addition, we were required to safeguard and promote the existence of the Gambia as a sovereign, independent state, the Gambia's republican system of governance, including its democratic values and respect for the rule of law and fundamental human rights and freedoms, national unity, cohesion, and peace, separation of powers, the importance of ensuring periodic democratic elections based on universal adult suffrage, including the introduction of term limit for the office of president, the continued existence of the Gambia as a secular state, in which all faiths are treated fairly and encouraged to foster national cohesion and unity. In carrying out these terms of reference, what we at the CRC consistently refer to as our guiding principles. We were instructed to afford the people of the Gambia, both within and outside the country, to the extent practicable, the opportunity to freely express their opinions and make suggestions on matters they feel should be considered in the Constitution. The Act then vested us with the power to, where we consider it necessary, invite persons, including professional, civic, political, and other organizations, to appear before the Commission to make such presentations as those representatives consider relevant, or make presentations on topics the Commission may specify. It also empowered us as a mechanism to facilitate and assist with our work, to establish such technical committees as we considered necessary and provide them with the appropriate terms of reference. In the performance of our functions as enshrined in the CRC Act of 2017, the Commission was declared not to be subject to the direction or control of any person or authority. Any person who had been following our activities from inception in June 2018 until 30th March 2020, when we formally presented the draft constitution to His Excellency the President, cannot but honestly accept that the Commission had followed every rule in the rule book handed to us. We consulted the Gambian public, both at home and abroad, at considerable expense, to determine their wishes and aspirations. We did our utmost to embrace in the draft constitution our country's national values and ethos. We tried to safeguard the Gambia's existence as a sovereign independent state, including its republican system of governance, while at the same time embracing our democratic values and respect for and promotion of the rule of law and human rights. We carefully considered the subject of separation of powers and worked to create an appropriate balance between the executive, legislature, and judiciary. We aim to increase and emphasize the cohesion, unity, and peace of our country, incorporating provisions that would ensure periodic democratic elections, including term limit for serving in the office of president. We recognize the secular nature of Gambian society and created provisions that, in our considered view, would ensure the equal and fair treatment of all faiths, which would in turn foster national cohesion and unity. The failure of the draft constitution to gain the required votes to move on to the next stages, leading to a verdict by the people at a referendum, has generated a lot of debate. We at the CRC do not seek to question parliamentary wisdom regarding the fate of the draft constitution. That is a political process from which we will stay away. It is therefore not necessarily my intention here today to get into the debate of what is or what is not or what could have been. However, for the sake of the integrity of the constitutional reform process and our own individual and professional integrity, I consider it necessary to address two matters that appear to have gained some traction in the public space. It is unfortunate that a tiny minority of critics have leveled the claim that the draft constitution was plagiarized. The CRC, with its team of experienced draftspersons and international consultants and drafters, has not given any credence to such claims and essentially viewed the claims as merely stoking emotions to back up the critics' rejection of the draft constitution. Indeed, there have been those that never said anything good of the CRC from the time of its inception. For them, it was personal. The word plagiarize relates essentially to copyrighted work that is protected and is used without the rightful authority. No constitution in this world is copyrighted, and that's for a good reason. Every constitution, including the Constitution of the USA, that has been touted as a model by some critics, has drawn inspiration from some one or more constitutions or other written literature. International experts on constitutional law advise reliance on best constitutional models for the development of new constitutions. We see the best example of such encouragement in the website called constitute.com, which collects and collates the constitutions of the world for purposes of serving as a reference to constitutional builders and researchers. If you go to the website today, you'll find our draft constitution on it. It is perfectly acceptable and indeed encouraged in the legislative drafting world that drafters of laws may draw inspiration from other written laws by adopting specific provisions thereof or adapting such provisions to special circumstances. This is not controversial, well, except in the Gambia. One only has to review various Commonwealth countries to see evidence of adoptions or adaptations. The Constitution of Kenya drew much inspiration from the Constitution of South Africa and was effectively the most modern on the African continent at that time. The Constitution of Kenya adapted and in some instances made better the South African constitutional provisions that it adopted or adapted. The 2010 Constitution of Kenya has been hailed as a forward-looking constitution on the African continent, whose development had had the benefit of domestic UN and other international expertise input. The Gambia shares the same Commonwealth tradition with Kenya and other Commonwealth countries. Constitutionally, the Gambia has more in common with Kenya, South Africa, Ghana, Nigeria, Sierra Leone, Uganda, Zimbabwe, Zambia, Tanzania, Malawi, Botswana, Namibia, Lesotho, and Liberia than it has with our neighbor Senegal or other French-speaking countries. I mention these Commonwealth countries specifically because the CRC has studied the constitution of each and where appropriate has drawn inspiration from them as circumstances required having regard to the Gambia's own special circumstances. The report accompanying the draft constitution is instructive on this. The CRC has not blindly adopted or adapted constitutional provisions from elsewhere. It thoroughly reviewed and applied them in the Gambia's own national circumstances, especially having regard to the opinions expressed by members of the public during the public consultation. It is from such sources that international best practices are gleaned. The constitutional history of the Gambia shows that the 1970 Constitution drew a lot of inspiration from the Jamaican Constitution of 1962, which it adopted. The 11 chapters of the 1970 Constitution are essentially the same as those of the 10 chapters of the Jamaican Constitution. Similarly, Chapter 3 of the 1970 Constitution was adapted from Chapter 3 of the Jamaican Constitution. The minor differences are in the areas of protection of persons detained during a period of public emergency, which the Jamaican Constitution did not have. Similarly, the Jamaican Constitution had no provision on prohibition of slavery and forced labor, which the 1970 Constitution adapted from the European Convention on Human Rights. In a similar vein, the 1997 Constitution of the Republic of the Gambia that governs us now drew enormous inspiration from the Constitution of Ghana. That is constitution building. Trying to denigrate the toil and hard work of the CRC on this issue has been most unfortunate. In a similar fashion, let me briefly take you through statute law. If you look at the Civil Marriage Ordinance 1910 of Sierra Leone, this was adopted by the Gambia through the Civil Marriage Act of 1938 and by Kenya through its Marriage Act of 1962, which had since been revised in 2012. The second matter relates to whether or not the draft constitution permits gay marriages. I thought we had thrashed this out properly during the public consultations and laid it to rest. But there seems to be new sermons on the subject. When we published the draft constitution, the proposed draft constitution in November 2019, we replicated in that draft the current section 27 of the 1997 Constitution. That created an uproar with claims that the draft permitted gay marriage because subsection 2 of that section indicates that marriage shall be based on the free and full consent of the intended parties without specifying who those parties were. From a legal standpoint, we did not think so, as the provisions of the section should be read conjunctively and not disjunctively. But we nonetheless sought to clarify the provision better, hence the current section 54 in the draft constitution. There were no issues with that provision during the second round of public consultations. Frankly, I cannot analyze the subject better than how the Foroya newspaper did in their editorial of 28 September 2020. The truth and fact is that Section 54 of the draft Constitution cannot, by any stretch of legal interpretation, be interpreted as permitting gay marriage. The irony, though, is that with the draft Constitution now halted on its tracks, we are stuck with Section 27 of the 1997 Constitution. I don't think I need to say anything further than that. I thank our external partners, beginning with the UNDP, who, apart from the assistance I mentioned earlier, also provided funding in excess of $10 million to undertake our internal public consultations, $40,000 US to our external consultants, and $3.8 million to support our technical committees. They also provided us with one vehicle, a Toyota Prado, and paid the first year's rent of the CRC's premises. Their assistance has been invaluable to our work. We also thank the European Union for their support and outreach to the CRC and for placing the Gambia's transitional justice in relation to constitutional review high on their agenda. I thank the government of Qatar for the financial support they gave to the government, of which the CRC became a beneficiary. I thank ECOWAS for the financial support they provided, which enabled us to launch and continue with our periodic CRC newsletter. Having been called to national duty and to give our best as experts and professionals in our respective fields, we have unfortunately become the subject of much disrespect, ridicule, and insult, much to the consternation of our families and friends. We must, however, move on, and I can assure everyone that we demit office with our heads high, holding no grudges, and harboring no anger against any person or institution. We feel satisfied with the product of our assignment. We continue to be very proud of our people, their resilience and love for country, but above all for educating us as we journeyed with them through the public consultation process. We are confident that all the good intentions that we all have, individually and collectively, to reform our governance system and improve the lives of our people will someday converge to make us a better people as one family, one tribe, one Gambia. I wish to encourage our citizens not to consider the money spent on the CRC project as wasted. I see a lot of debate on this. Far from it. It is amazing how fast our people have learned so much about the Constitution and what it means and what it stands for. The draft Constitution